Court is calling 2023 CR 6906, State of Texas versus Tyree Joseph Ranford. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Robert Gayona.
Are you Mr. Ranford?
Yes, ma'am.
This case is about more than just probation violations. It's a collision between second chances and repeated mistakes. Tyree Ranford is back in court facing serious allegations while already on thin ice. But as you'll see, this courtroom isn't just deciding his fate, it's delivering a reality check. Will the judge give him another shot at redemption, or is it time to face the full weight of the law? Stick around, the tension is real, the stakes are high, and the decisions made in the next few minutes will change lives forever. And wait till you hear what the defendant has to say, it might just surprise you.
Yes.
Violating condition number 1, under the 12th day of April 2024 in Bear County, Texas. The defendant Tyree Joseph Ranford committed the offense of fraud and violation of condition number 1.
How do you plead to that? True or not true?
Sure.
Your Honor, will waive the remaining violated conditions.
Yes, one moment. Any objection to the waiver?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and send?
Right here, the judge clearly lays out the consequences. Up to 20 years in prison and a $10,000 fine. This isn't a slap on the wrist, it's a legal turning point. By pleading true, Ranford is essentially admitting guilt on a major violation. This is the kind of moment where defense strategy is critical, but once that plea is entered, the court holds all the cards.
No, Your Honor.
All right, state, what are you requesting?
Verification, Your Honor. And just for the record, we have agreed to TIC night bag 754625, which is a possession case which was alleged on the NTR, and also night bag 760242, which is the fraud case that you pled to. Other than that, Your Honor, it's open to the court, requesting revocation.
All right, defense, are you in agreement with revocation?
We are in agreement. We're not in agreement with revocation, Judge.
This is where the defense tries a softer appeal, emotional reasoning over legal facts. Notice how the attorney shifts to the idea of trying again, hinting at rehab and recovery. It's a bold play when the judge already has violations on record. Do you think emotional appeals should carry weight in repeat offenses like this? Drop your take in the comments.
To be successful and complete that lifetime recovery. In the alternative, he's requesting from this court to, if the court deems it's proper, to sentence him to TDC, to sentence him to the minimum of 2 years.
All right. So why is he picking up new charges while he's on probation?
He can answer that.
All right, do you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Tyree J. Ranford.
All right, what would you like to say?
Basically, I haven't been making the right choices. And I understand that. And I understand that, I'm being held accountable for the choices that I do make. And right, wrong, and indifferent, even if I'm,
I'm sorry, she can't hear you. You need to speak up.
I'm saying, right, wrong, or indifferent, whatever, indirectly or directly, the choices.
This part hits hard. Ranford owns up to his choices, no excuses. He admits that who he surrounds himself with, what's in his car, even what he doesn't know, it's all on him. This is what judges want to hear, accountability. But will it be enough to undo the damage done, or is it just too little too late? Accountability, but will it be enough to undo the damage done?
So I take full accountability for that, but I would like a chance to be reinstated based on the fact that I'm choosing to do right, and I'm choosing to wanting to succeed.
I mean, but choices that are made need to be made while you're on probation, not when you have a motion to revoke. What have you done since you've been on probation?
Well, I have, I've stuck to all my appointments up until the time that, I found out that it was wrong for me.
Okay, I can't understand anything you're saying. You're gonna have to open your mouth and speak.
I did choose to show up to all my appointments for probation to my probation officer up until the time that I found out that one was put out and whatnot. And I did do all my drug tests.
Deputy Lord, the issue is not the mic. He just won't open his mouth to speak.
But I did go to all my drug tests at Lifetime, so I have all of that, and basically that's it, but I did show up. On my point.
All right, so a part of your plea bargain agreement, the state was silent on your application, so you had to come to the court to ask for probation. The state said, we're not going to say you don't have probation. We're not going to say to give you probation. So you had your chance to be on probation, to do.
Boom. There it is. The judge is done playing the maybe next time game. She reminds Ranford that he already got his shot. The state didn't object to probation before, he just didn't follow through. And let's be honest, if you're given a second chance and still violate probation, what more can the court do? Is the system too lenient or too unforgiving?
754-625. Does anyone want to speak in regards to punishment? State?
State's requesting minimum 6 years.
All right.
Judge, we'd ask that you sentence him to the minimum, which is 2 years. Give him credit for all time served.
All right. So what I want you to know, Mr. Ranford, is I always listen to both sides. Sometimes I'll write down a number before either party says anything, because those are things that are in my thoughts where I think the case was.
Yes.
So I want you to know that even though the state is recommending 6 years. All right. So the court is going to sentence you to 6 years.
6 years, that's the verdict. The minimum could have been 2, but the judge didn't buy the defense's argument. And notice she says she listens to both sides. That's important. Judges aren't robots, they weigh each case individually. But when the pattern is clear, like repeated violations, the law speaks louder than intentions.
Yes, Your Honor.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the, I'm sorry. Pass that back just 1 second. You do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Do you understand?
Yes, Your Honor.
All right, because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a felony is, or if you have a question over what weapons or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. I take no joy in sentencing people to prison.
This moment right here is the long-term impact many defendants don't fully understand. A felony conviction doesn't just end at prison time, it affects your right to own weapons, your employment opportunities, even housing. Ranford may serve 6 years, but the legal shadow could follow him for life.
Okay?
Yes, Your
All right, good luck to you.
Yes.
Court is calling 2022 CR 6621, State of Texas versus Justin Kyle Perry. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Adam Hood for the defendant.
Are you Mr. Perry?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Justin Kyle Perry who was placed on deferred adjudication in 2022 CR 6621 for the offense of aggravated assault with a deadly weapon on November 14, 2022 for a period of 4 years? Is that
Just as one case ends, another begins. Enter Justin Perry, another defendant facing the music. Different name, same story, deferred adjudication, probation violations, and now the court must decide his fate. But this time there's an aggravated assault with a deadly weapon in the background. Things are about to get even more intense.
how do you plead to that? True or not true?
Sure. Your Honor, state waives all the violations.
Any objection?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and an up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, it's the alternate amend for Bear ISF with ISP supervision after discharge, registration for classes within 30 days of release, verify employment within 30 days, and a 2-year extension.
All right. So this is not the first time he's been here on a motion.
This isn't Perry's first time on this ride. The court has already granted him ISF Intermediate Sanction Facility, basically a last chance boot camp before prison. Yet here we are again. When judges see repeat ISF failures, their patience runs thin. How many chances should someone get? Let us know what you think. Is the court being too generous or just fair?
Like another chance to try to do it again, man. I know I made a mistake.
No, these are not mistakes. These are choices. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name's Justin Kyle Perry.
All right, so I'll listen to whatever you have to say, but I want to let you know that we've done ISF with you before. And my understanding is that the rules of ISF were explained to you, and it was explained to you what you're supposed to do after you were released. And I know if you appeared before me, then I told you if there were any issues, you could let probation know. And if they were not addressing those issues off the record, she's just came in the waiting room. If it's Gloria Cardenas. Yes, Judge. Back on the record. And then I know I told you that if there are any issues, you could always come back to the court if probation wasn't addressing those. So why would I put you back on probation when we've already done ISF with you before and we've already done ISP?
It's a different situation now that I'm getting released. I got out of the bad situation I was in when I got out the first time, and I was dealing with a sick grandmother. She had just died on November 19th, so I kind of fell off, but now I'm more clear-headed and I'm out of that bad situation with family matters. So now I can actually do it, and I know I can complete it.
I mean, we say that, but I mean, have you done anything on probation?
No, ma'am, I didn't. My grandmother died as soon as I got out, and I lost all track, focus of anything.
All right. Is there anything anyone wants to say on his behalf as to why I shouldn't revoke him?
Judge, we're hoping, we certainly know and respect and understand it's within the court's power to do that, but we're hoping that the court sees fit to give him a chance. Everyone's needs in terms of treatment are different. I believe he can be successful. I think he will be successful in probation. ISF, ISP, certainly nothing easy to go through. We're hoping to avoid the chance to be a convicted felon, continuing this gift that he has with deferred adjudication, and hopefully be successful, Your Honor.
All right. This is what the court is going to do. The court is going to grant the motion. The court will find violation of condition number 4 true. The court will find you guilty. The court will sentence you to
2 years in prison. That's the final ruling. Even with the emotional testimony and second chance requests, the judge stands firm. She gives credit for time served and orders therapeutic programs, but still accountability is not negotiable. Perry's deferred adjudication just became a full conviction. That's the power of the courtroom. Decisions that change lives in real time.
of defendants' rights to appeal. Did you review that with your attorney? Oh,
Sorry, Judge.
Oh, no problem. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, you do have a limited right to appeal, and that right to appeal is as it relates to the allegation in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you are not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I understand that everybody has issues, but we can't keep doing the same thing over and over and expecting different results. So I know that in this court, I give
2 defendants, 2 chances, 2 very different outcomes. What we saw today wasn't just law. It was accountability, remorse, and the limits of second chances. The courtroom isn't where stories end, it's where they turn. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns every day. This is Ruling Hub, where justice meets reality.